bid petitioners / purchasers had challenged the order of the additional member Board of Revenue. Yes.
Your Lordship, this matter was the matter is pending on two grounds. This LP has been filed. The matter is regarding a preemption of land, and the judgment was in my favor since 1988, before the DCLR Shirghat. The preemption was allowed to me. The law came into effect in 1990.
That's not only with respect to law; it's with respect to no notice having been served upon.
Yes.
Upon the respondents here.
Lordship.
That's the only reason.
The order sheet of the Board of Revenue clearly states that notices were issued.
No. The single judge says that I have perused the counter affidavit and the specific averments made in paragraph 12 of the counter affidavit. Though there is averment that notices were issued to the petitioners, there is no material to suggest that notices were in fact served upon them. Now, repelling the argument made on behalf of the petitioners that no notice was served and they had no knowledge about the revision application before the learned additional member, Mr. Gopalji, that's for you. Mr. Gopalji, learned counsel for respondent number 5 and 6 contends, referring to order sheet of the revision case, that notices upon the petitioners were in fact served. The order sheet of the revision proceeding has been brought on record, Annexure 6, from which it appears that revision application was dismissed on 29/6/1994 for non-prosecution.
My Lord.
And after the restoration, there is nothing on record that notice was ever issued. Now, you can argue only to the extent that with the restoration, the entire file gets restored and therefore no fresh notice is required. But then that argument you will not be able to push beyond a point. That's the only ground. That's the only thing that appears to catch the attention of us.
My Lordship, I pray for some time.
No, time winding.
To give an evidence in document.
Otherwise, also nothing.
My Lordship, there is the order sheet of before the Revenue Board clearly states that notices were issued
after the restoration of the case.
Yes, my Lord. Yes, my Lord.
That way you will be. Where have you said in your memo that the observation of the learned single judge is incorrect factually? Now, Narendra's case, unless the order passed by single judge is perverse, in appeals, in intercourt appeals, it should normally not be interfered with. So I have been interfering with such orders, but then here we don't find anything. Sorry.
Just some time, my Lord, just to bring in documents before my Lordships, that the order was prevalent.
Document कुछ भी नहीं लाएंगे इसके अलावा. जो writ petition में जो document लगाए हैं, जो अभी है, इसके beyond कुछ नहीं कर सकते. लिखिए. There's no use. ऐसे तो आप इस तरह से प्रे करेंगे तो मैं क्या कहूँगा मैं फिर आपको फिर समय दे दूंगा पर चीज वही रहेगी.
नहीं हुजूर को ये सेटिस्फाई करूंगा.
कैसे सेटिस्फाई करेंगे? कोई अलग
विद द ऑर्डर शीट माय लॉर्ड
नहीं देख पाएंगे अलग से ऑर्डर. ऑब्जर्व कहाँ आपने वही तो कह रहा हूँ मैं. आपने लिखा नहीं समझ रहे सर.
हम समझ रहे हैं.
अगर आपने लिखा होता कि सिंगल जज का ऑब्जर्वेशन फैक्चुअली गलत है तो मैं करता. अब आपको फिर समय दें दूसरा डॉक्यूमेंट लाने को. ऐसा एलपीए का स्कोप नहीं बताता.
हुजूर से ये प्रेयर है हमारा. हुजूर दो बातें हैं. एक तो ये 16(3) जो है ये
खत्म हो गया.
हो तो गया लेकिन मेरे पक्ष में ये ऑर्डर
वो बहस आपकी चलती. हुजूर एक मिनट सुनिए तो सही. जहां बहस करना चाहिए कन्वेंस हो गया था. कन्वेंस हो गया था.
नहीं रजिस्ट्री नहीं हुई थी.
तो फिर एट एनी स्टेज यही तो ग्राउंड है जिसकी वायरस अभी टेस्टेड है. टेस्ट होने को रखी हुई है DB1 में. And few matters are pending before this court also. Completion does not mean that it is only at the level of the court decision. It must be completed. नहीं वो ठीक है कर सकते.
नहीं it reads.
Just a minute,
my lord.
ये कोर्ट से मतलब नहीं. अगर एग्जीक्यूट नहीं हुआ है तो उनके नाम से ट्रांसफर रिकन्वेड उसको हो गया था.
Execution was similar to some young years. despite of the interim order filed with the record. The order sheet suggestion of second paragraph, first page.
नहीं preemption कहाँ से? इसको restore कर दिया था क्या?
My lord, even in
एक second रुकिए सर. नहीं तो हो गया.
Execution of said lead.
उसको सिंगल जज ने नॉनेस्ट मान लिया कि इंटरिम ऑर्डर के खिलाफ. द मैजिस्ट्री ऑफ लॉ लाइज इन करेक्टिंग द डिफेक्ट. वी कांट टेक एडवांटेज. दूसरी बात कंप्लीट कि उसको सेट सही कर दिया, कंप्लीट हुआ नहीं, अब जहां है वहां रह जाएगा. एवरीथिंग अवेट्स.
सबमिशन मेरा हुजूर इसके सामने ये है कि हुजूर द DCLR had allowed the preemption in 1988 as per the direction of this High Court in 1979 in a writ petition in this High Court itself. According to that, after that,
अगर ऐसा होता तो बोर्ड ऑफ रेवेन्यू इंटरिम ऑर्डर नहीं करता स्टेटस को.
हुजूर मेरा सबमिशन इतना ही है कि 88 के बाद 91 में ये रिपील आया लॉ पे, एंड एट दैट टाइम द केस वाज नॉट पेंडिंग, एंड एट दैट टाइम आई वाज
इमीडिएटली प्रायर टू इट
रजिस्ट्री तो उस वक्त नहीं हुई.
नहीं वो इमीडिएटली प्रायर टू इट आप अपने फेवर वाली पॉइंट नहीं बोल रहे हैं. नहीं कैसे हुई थी. इट वाज रिकनेक्टेड टू यू
माय लॉर्ड,
एंड agreement was the sale deed was registered. वो इतना होगा कि सेल डीड रजिस्टर करके उसने परचेजर ने पैसा लौट दिया था. उन्होंने सिंगल केस में कहा है कि पैसे लौटा दें.
ये ऑर्डर में नहीं है. इट इज जस्ट द इन्वोकेशन.
जस्ट अ मिनट
माय लॉर्ड.
उन्होंने पैसे लौटा दिए. वो है ना कि अगर प्रीएम्पशन हार जाते हैं तो जो 10% अमाउंट जमा किया है वो लौट जाएगा. There are some decisions which say that with the return of that amount, the proceedings get closed, and therefore 16(3) the Repeal Act becomes operative. है ना? तो इसको डाल दिया. अब इसको पॉश कर दिया. सिंगल जज ने उसको पॉश कर दिया. और पॉश करने का मतलब हुआ कि वो चला गया वो परचेजर के पास. चला गया वो परचेजर के पास. ठीक है. तो ठीक है. तो परचेजर का राइट है. तो प्रीएम्प्टर ने जो पैसा जमा किया था और वो किया था उसको रिटर्न होगा ना. आपको उनकी जमीन से कब्जा भी हटा दिया ऐसे. Who was your vendor? Who was your vendor?
Nurul Hassan and Zubair Singh. No, my lord. The respondent number 7 and 8, Mahendra Prasad and Ratan Prasad. They were the vendors. They are the sons of the original landlord. And despite notices to the opposite parties, they did not come for registry.
You file your response. This is the issue which is bothering us. This is the issue which is bothering us. Now, good, bad, indifferent. There are two things. He may not have argued it, he may not have put it on record in his memo that means. Now, before the repeal, the transaction was complete. Nothing was left to be done. The land was reconveyed, money realized, sale deed executed. Now, after the repeal, it could not have been reopened. Even assuming that the reconveyance of property to them was bad in the eyes of law because of the same having been done during the operation of a stay order passed by one of the authorities. But once it, so therefore if we return it, then something has to be done to have it restituted. Now land, of course, the purchaser keeps the land, but reconveyance, इसमें केवल लिख दिया इन्होंने the consequences would follow. इसका क्या करेंगे? The application was therefore restored to original file. It said consequences of the quashing of the impugned order shall follow. This makes, then you go before the court. Take that. Even one sentence, one word makes a difference. I was about to issue notice to the vendors, was about to issue notice to the other side and asking the court, asking the state to explain. But then one line in the order justifies it. Consequences of the quashing of the impugned order shall follow. That means that you have to now do the rest of the work. You have to approach your vendor, have the money returned. You can't help it. This is what happens when a bad order is passed. And when you are a purchaser or a preemptor or whoever, principle of caveat, for purchaser, caveat emptor applies. But you are a preemptor.
My lord, this one prayer is there that at that time the money was not returned and the transaction was not complete under section 16(3). So can I have a...
If it was not done, then also the order goes. Now that also does not come to your assessment.
Because previously the order was prevailing in my favor, and at that time it was not sub judice, and when the invocation of 16(3) was...
Preemption की जब conveyed हो जाती है, उस समय नहीं हुआ था तो नहीं हुआ. Then the purchaser's right concretized.
Even the return of the money.
देखिए, हर्ट क्या नाम है आपका?
एडवोकेट शफीउद्दीन अहमद.
नाम केवल पूछने से एडवोकेट से प्रिसीड क्यों करता है?
सर.
हाँ? फिर बताइए नाम क्या है?
शफीउद्दीन अहमद.
Shafiuddin Ahmed. Heard Mr. Shafiuddin Ahmed for the appellant and Mr.
Asif Kaleem.
Asif Kaleem for the state. The appellants are the preemptors who have challenged the order dated 7/8/2019 passed by the learned single judge of this court in CWJC number 12754 of 2099, whereby the order dated 20/11/1995 passed by the learned additional member board of Revenue Bihar in case number 460 of 1993, allowing the claim of preemption, was set aside, and it was ordered that the consequences of quashing of the order would follow. It appears from the impugned order that the purchasers writ order, it appears from the order passed in the writ petition, it appears from the perusal of the order dated 7/8/2019 impugned in the present appeal that the writ petitioners / purchasers had challenged the order of the additional member Board of Revenue dated 20/11/1995 on the ground no, just cut it. It appears from the order impugned. It appears from the order impugned that in the writ petition filed by the purchasers (respondents herein) a status quo order was passed by the learned single judge on 5/3/2001 despite the said interim order of 5/3/2001 referred to above. The land was reconveyed to the appellant's preemptors with the execution of sale deed on 9/5/2003, invoking clause 3 of subsection 3 of section 16 of the Bihar Land Reforms (Fixation of Ceiling Area and Acquisition of Surplus Land) Act 1961. The learned single judge, after having perused the entire documents, found that the purchasers were never noticed, were never served with the notice. Finding that the land in question was reconveyed to the appellant's preemptors during the period when the order of status quo was operative, the learned single judge quashed the order passed by the additional member Board of Revenue as the principle of natural justice had been put on hold. We have no reasons to interfere with the order, even though the appellant's preemptors have paid for the land to the vendors. Since the single judge's order reveals, since the order impugned specifically provides that the consequences of quashing of the order of the additional member Board of Revenue shall follow, it is for the appellants to approach the authorities for the return of the money. The appeal is dismissed, but without any orders.